first matter to come before the court this morning is State of Ohio versus Jonathan Fedrick. Mr. Ludwig, you have 15 minutes with which to present oral argument. We have read the briefs. We are ready to see the argument.
Thank you, Your Honors. Good morning. May it please the court, I'm Mark Ludwig. I have the privilege of representing Mr. Fedrick by appointment of the trial court. I would be remiss if I did not say welcome to Judge Teodosio.
Thank you, Mr. Ludwig.
In March of 2015, Mr. Fedrick ended up being charged with 10 counts, some of which he took to trial and some after trial he pled out. We are basically questioning two sentences here. A sentence for felonious assault with a gun spec and a weapon under disability. Both of these arose out of the second incident in March, and both of them and these charges were the subject of jury trial. We have assigned 3 errors about a failure to charge the inferior offense of aggravated assault, errors concerning merger and maximum sentence, and an error regarding the verdict form. There is no dispute that Mr. Fedrick shot his uncle, Reuben Ruppel. Mr. Ruppel was then age 39. He has 5 sons, 6 through 10. These gentlemen both have a history with each other that is perhaps not unique in our families, but was their unique family history. I'd like to try and address these in reverse order for the simple reason that the verdict form issue, if the court accepts that verdict form issue, we end up with a conviction for simple assault, and at that point, Mr. Fedrick and I both will run away very happy about the result. He still will face substantial sentences in terms of what he's pled to and in terms of the conviction for weapon under disability. The question of law that we present about the verdict form is both constitutional under both our constitutions in terms of multiple punishment. We also suggest that the state's response to the assignment of error was that Benford sets the standard of review, an earlier decision of this court, sets the standard of review and controls. With all due respect, the easiest way to say this is Bedford's wrong. But it can be distinguished without having to be overruled. Benford talks about a statute that has been amended 4 times since Benford was decided. Benford was decided before, and I use the word respectfully, the Ohio Supreme Court clarified the verdict form issues with McDonald and Pelfrey. After Pelfrey, there were 3 decisions that, quote, clarified that law. Whether this court feels those have been clarifications or not, we'll decide when you go over them. But again, Benford was decided before the, quote, benefit, close quote, of those cases. Benford is wrong in part because of these words contained in Benford, that assault is not a lesser included offense of felonious assault. Well, is it wrong? It is. And this court said so in 1987, a decision that kind of was not mentioned in Benford. Benford also, and we've addressed this in more detail at pages 18 and 19 of our brief, adds words to the Pelfrey test. And the words it adds are about the crime you're currently charged with somehow controlling what the verdict form should be. And Pelfrey didn't say that. And McDonald and it's the other 2 cases since Pelfrey have supposedly clarified that. But the bottom line is that the verdict form, let's not worry about how some broad general rule is going to be created if we decide there should have been, this should be reduced to simple assault. Look at the verdict forms. These verdict forms make no mention of a statute. in the body of the verdict form, recite none of the elements of the offense that goes to the jury. In the caption, it says felonious assault. These verdict forms also discuss counts 1 and 2, or vice versa, 7 and 9, which were not renumbered versus the actual indictment. These verdict forms, I doubt very much, will ever be duplicated in their lack of specificity by any of our trial courts. So saying in this case that those verdict forms were insufficient doesn't open a floodgate of every felonious assault case must have a verdict form exactly that excludes simple assault. It's not that broad. It is limited to these narrow verdict forms that are erroneous. And again, there was no objection at the trial court by the defense counsel. Thank goodness, this is one of the rare areas where defense counsel doesn't object. The blame is always placed under Pelfrey and its line directly on the trial court and the prosecutor's office. And in all deference to that, I don't blame trial courts when the primary responsibility to prepare that verdict form and make sure they get a good conviction belongs to the prosecutor's office, not the judge. Belongs to the prosecutor's office. They're the ones not giving guidance in offering a verdict form. Now, should a judge look it over? Sure. I'm not going to try and convince this court that you've got nothing better to do as a trial judge than sit around and double-check verdict forms that both parties, quote, agree to. The second issue that we presented, and again, if that verdict form is found defective, we're back to a simple assault. Maximum on it's a misdemeanor, six months, and there's still remaining sentences that Mr. Fedrick will have to serve. The question as to the sentences, again, go to the constitutional double jeopardy issue. Both the U.S. Constitution and the Ohio Constitution independently would support a reversal. But there's two questions we present, the merger and the max and consecutive. And if the court please, the prosecution opposes this standard of review based on the wrong standard. The prosecution's brief, the state's brief, cites the line of cases this court had in Kalish. And as this court decided yesterday in Wood, the Markham case in 2016 is the test we use to review sentences, not the Kalish line. I would respectfully submit another thing that makes this case unique is we've questioned the sentence. The state of Ohio has opposed that with the wrong standard of review. From my standpoint, and on behalf of Mr. Fedrick, those are unopposed. When you invite this court to use the wrong standard of review, instead of the standard that the Ohio Supreme Court established in 2016, you haven't opposed what we're complaining about. The primary area in the imposition of maximum and consecutive sentences is this. During sentence, the trial court clearly was invited and did find that Mr. Fedrick was a repeat violent offender. The prosecution said you've got to hammer him to the max because he's a repeat violent offender. Problem with that, as the prosecution knows, is that under 2941.149, a determination of repeat violent offender is precluded. Not just at sentencing, but it's precluded, period, unless you're indicted as a repeat violent offender.
Well, there was no RVO on the indictment.
There was not.
Wasn't the prosecutor just characterizing the defendant's prior record when he used those words?
I'm sure that's the dodge they use, Your Honor. I'm sure it is. But it is not a successful dodge in this sense. The phrase repeat violent offender is defined by our legislature. And when a prosecutor uses it, I think it's fair to assume they're pointing to the legislative definition. And the legislature has said you're precluded from making that finding. unless you're indicted.
Did the court ever make a finding?
It did not specifically state, I find he's a repeat violent offender. There is sufficient language in the sentencing that one could fairly assume, and why should we? We shouldn't have to decide whether or not he did that if the prosecution doesn't invite that, and they invited it. In terms of the max and consecutive, that's the principal thing. The merger question is quite clear. We've got a felonious assault and a weapon under disability. Same weapon in both usages.
Different dates?
No,
Same date?
no, same date, same offense. There is another weapon under disability that he did plead guilty to that was done 10 days before. Different firearm, different disability, I mean, same disability, but totally different. He was not sentenced on that. He was sentenced on the one connected to the same day shooting. And the prosecution's best answer to that is, well, it wouldn't merge because he had the pistol with him twice in that day. Well, we now have 24 counts of weapon under disability. If every hour that you possess the weapon, it automatically means it's a separate offense. That, as much as Ruff helped us with the definition of what is a separate offense for allied offenses, Ruff doesn't suggest that a finding that you had the gun at noon and you had it again at 10 is sufficient to find that you have separate animus as to possession of the firearm. Especially, I'm sorry.
But wouldn't it also state that if you have it at 10 and you leave and you go away, and you come back at 12, and you have it again, and there's different people present, different events occur at two separate times, wouldn't that be, instead of having it continuously for 24 hours, it's just two separate events on the same day?
It would be an argument that could be made and that a trial court may make a finding and find. But why are we doing it for the first time on appeal? And you've got enough to do. When there's a weapon under disability and a felonious assault charge, what the Fedrick case will say to trial courts is slow down, take a look at whether there's a merger. Hopefully it also says it to the prosecutor's office. Slow down, take a look, and see if there's a merger. In this case, yeah, they were separated by a few hours. But the possession of the firearm, the facts in this case, kind of show that he was always possessing it with the animus of, look at my gun, I'm in charge, I'm going to fire it. Because he went over earlier, fired the gun, came back, still had the same gun. I don't think merely leaving meant his animus changed. But again, why are we doing that for the first time here? And in terms of the aggravated assault, first assigned error. Now, there's no doubt that aggravated assault is an inferior offense to felonious assault. The trial court denied, let me back up quick for a second, the standard of review, we've both agreed in our briefs is abuse of discretion, but as of preparation for this, and I'll file a quick supplement, and I'm sure the state will want to respond, that medical mutual case that talked about hearsay can invite a standard of review of de novo. It basically says if the error is one premised on an error of law, then it is de novo review, even though what traditionally was abuse of discretion, the admission of hearsay evidence, was under the abuse of discretion. This may be an abuse of discretion, a de novo review case. However, the way out of that is simply this. If it was abuse of discretion not to give it, it doesn't make any difference that you should have made the decision under de novo review, because the abuse of discretion is a tougher standard. So if we've met that, it doesn't make any difference. The court denied this aggravated assault on the basis of, number one, it was just mere words. Well, when you go through the record, that's not it. That's not true. The trial court's finding that this was just mere words is not true. This was, after he came back, we observed the victim open his trunk, get something out of the trunk, we don't know what. and then walk towards Mr. Fedrick, taking off his coat and saying, "I'm going to kill you." We don't ask Ms. Sheets to jump in front of me. But again, out on the street, "I'm going to kill you," number one, walking towards a guy with a gun is crazy. But number two, it might, by a jury, be found sufficient to excite Mr. Fedrick, who already was in an excited mood.
And Mr. Ludwig, regretfully, I need to let you know that you have utilized your entire 15 minutes.
Thank you.
We thank you. Court will take the matter under advisement. We wish a written decision, which we mail to both sides, as well as posted on the Ohio Supreme Court website.
Thank you.